He is out and he is doing really well out, Your Honor. Since he's been out, as you know, he has successfully completed his inpatient treatment. Currently, the court has him on GPS tether, which the court tends to do when we put them in treatment. My client has had no subsequent violation. He currently has stable housing. He has family members. My client is just asking that the tether come off, Your Honor.
Here, Aubrey takes a very different path, accepting a plea deal to a lesser charge, avoiding harsher penalties, and habitual enhancements. The judge carefully confirms every right waived, locking the plea in. This decision trades uncertainty for control, but consequences remain, including possible restitution and license suspension tied to the offense.
And Assistant Public Defender Jay Bellinger on all cases not ending in 1665.
I didn't do that.
I don't know.
Anyway, go ahead.
And James Fifelsky appearing on behalf of Mr. Mood on Kate Bennington 1665.
Mr. Mood is appearing via Zoom this afternoon. Mr. Mood, can you state your name for the record?
I'm Giovanni Mood.
Got it.
And Your Honor, at this time, we are asking that his matters be set for preliminary examination.
That is correct, Your Honor.
Discovery is complete.
To the best of our knowledge.
Yes, Your Honor.
And would the witnesses be available the 24th? All three of his cases will be set for preliminary examination, March 24th, 2026 at 9 a.m. Bond, that's an in-person hearing, sir, so you have to come down to the courthouse. Bond will continue.
What judge is that?
Or judge. Before who? Me? Before Simpson, before myself. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Court does call the case, People versus Rachel Pichette.
Oh, you're in trouble.
Good afternoon, Your Honor. Sydney Rushing appearing on behalf of Ms. Pichette.
Hi, Rachel Pichette.
Your Honor, I was just appointed on this matter yesterday, so we are just seeking an adjournment for discovery to be received for me to talk about it with my client and negotiate with the people.
Yeah. Probable cause conference will be adjourned to April 2nd, 2026, 9 a.m. Bond will continue. All right,
Thank you so much, Your Honor.
Thank you. Court calls the case, People versus Eric Mayfield.
Sorry, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Mayfield, who is unmuting himself now. Mr. Mayfield, could you unmute yourself and take the court?
Hello,
State your name.
Eric Mayfield.
And Your Honor, we are requesting adjournment. It's the first PTC. I just need more time to go over the case with Mr. Mayfield and figure out a plan.
That objection, probable cause will be adjourned April 2nd,
Thank you.
2026, 9 a.m. or as your invite indicates, Bond will continue. Thank you. Thank you, Mr. Mayfield.
Thank you.
Court calls case of the People versus Dion Nelson.
Good Judge, Attorney Feaster on behalf of Mr. Nelson, who's approaching the podium. When you arrive, please state your name for the record.
Dion Nelson.
Hey, Dr. Potter. Thank you, Judge. I have attended to the court of green sheet. We are still in review of his discovery. He's asking for a 2-week adjournment so we can further review his discovery.
Probable cause conference will be adjourned March 26, 2020. 9 a.m. Bond continue.
Thank you, Judge.
Court calls case People versus Francisco Quezada Larada.
Assistant Public Defender Chinazi Carey, Your Honor, on behalf of Mr. Loretta, who's approaching. State your name for the record, please.
Francisco Andres Casal Loretta.
Judge, we're asking for an adjournment today. I had a green sheet.
You had like 8 of them.
I did.
Would pull one out. Fine, we'll wait for it.
I think it's in the office, Judge. I will give it right back to the court. The people have extended an offer. I've let,
Go through there with
that's right, Judge. Thank you.
cross client conference, March 26th, 2026, 9 a.m. Or as your invite indicates, we'll continue.
Okay.
All right, thank you.
And thank you. So I will say.
Okay, all right, thank you.
Yeah, we won't hold our friends to that group. Anyway. Court calls the cases of the people versus Justin Randolph.
Good afternoon, Public Defender Davi Leba for Mr. Randolph.
None.
No, Your Honor, Mr. Randolph is in the Livingston County Jail.
Oh, he is in.
Yes, I did speak to him yesterday. I'm going to be requesting an adjournment so that he can appear.
Okay, I will. Was he gonna get out soon or?
Back to be released on Monday, Your Honor.
Oh, this Monday coming up? All right,
Yes, he wasn't 100% sure, but that was his expectation.
got it. Well, why don't I do this? Let's go March 26th, 9 a.m.
Thank you, Your Honor.
Court does call the case of the people versus Norman Reeves.
Assistant Public Defender Davi Leba for Mr. Reeves.
In the end, we see two completely different strategies. Quinn risks trial with higher stakes, while Aubrey secures a controlled outcome through a plea. Both decisions carry consequences that will shape their futures in court. Which approach would you take? Like, comment, and subscribe for more powerful courtroom stories and breakdowns.
Can you tell the judge your name, sir?
Norman Reeves. I have a plea form. That's what we're doing today.
It is, Your Honor.
The people extended an offer plea to an added three, a sex offender's failure to sign registration. That's MCL 28.7293. That is a 93-day misdemeanor and a $1,000 fine in exchange for 1 and 2 to be dismissed. I would have had to take the plea to the.
Pardon?
I said I think we would have to take the plea to the higher.
Higher offense of the failure to comply with reporting duties or. Okay.
Thank you, Your Honor. I believe we do also have an agreement to no upfront jail.
That is what the form indicates. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole, truth, nothing but the truth, so help you God? Raise your hand.
Norman Reeves. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of failure to sign registration regarding sex offenders. Is that correct? Yes, sir. Now that's a misdemeanor, punishable by up to 93 days in jail, $1,000 fine plus court costs. You understand that? Yes, sir. And this is my case. So understanding all of that, do you still wish to plead guilty? Yes, sir. To that charge, how do you plead? Guilty. Now you understand that by pleading guilty, you will not have a trial of any kind. Sir. You signed an advice of rights form, is that correct? Question regarding any of those rights? No, sir. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on there. Yes, sir. You understand you're giving up your right to appeal of right. Yes, sir. Are you on probation or parole? I am. All right. Were you on probation at the time of this offense? No, sir. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No, sir. Anybody threaten you or coerce you? Sir. You're doing this voluntarily? Sir. And of your own free will? Sir. All right. And also because you believe that you're guilty? Yes, sir. All right. Why don't we do it this way? October 24, 2024, Scenic Lake Drive. Were you an individual who would be required to report as you are a convicted sex offender? Yes, sir. Yes? Yes, sir. All right. And did you fail to report? Yes, sir. I think I'll do it that way. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time that I accept your plea and the time of sentencing, that you two things would happen. One, you could not withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rules?
Yes, Your Honor.
People are satisfied.
Court will accept the defendant's plea of guilty to counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be
At 9 a.m.
April 8th, 2026, 9 a.m. That is before me.
Thank you, Your Honor.
Thank you. Call sir. Do me a favor, when you're on your way out, on the left-hand side is my probation department. Stop in there, tell them that you just took a plea so that we can start the process, okay? Sure.
What was the date of that?
April 8th. Court calls the case, People versus Cole Reynolds.
Alex Jablowski.
And Laura Yagi, Assistant Public Defender, on behalf of Mr. Reynolds.
Not true.
Not here. And also there's a violation, so probably not expecting him. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000, cash surety. That warrant will issue immediately.
Thank you.
Court calls case People versus Alan Rogers.
Your Honor, ring people.
Stephanie Can on behalf of Mr. Rogers. Mr. Rogers, could you please take the record?
Alan Rogers.
Yeah. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates the defendant's going to plead to an added count 3 of use of a controlled substance, a 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is agreeing to participate in substance abuse. That's court's full understanding of the agreement.
That's correct, Your Honor. Record the people did receive documentation from defense counsel showing that he has participated in that treatment now, so I believe that conditions.
Okay.
That is correct, Your Honor. He has successfully completed.
Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Alan Rogers.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of a controlled substance. That is a misdemeanor, punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and that you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Sir.
Signed an advice of rights form, is that correct?
Sir.
Question regarding any of those rights?
Yes, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on there.
Right from the start, this courtroom heats up fast. Tammy Johnson faces serious probation violations tied to a massive $74,000 restitution. The judge is already locked in, questioning effort versus excuses. This isn't just about money. It's about accountability. Stay tuned. This gets intense. Subscribe now for more gripping courtroom breakdowns and real legal drama.
Yes, sir.
I understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily,
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of July 19th, 2025, at the local McGregor, Ypsilanti Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
You know what you were using was cocaine?
Yes, sir.
All right. Sir, if between the time that I accept your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would, first of all, not be permitted to withdraw your plea, and the court would no longer be bound by any sentence recommendation or evaluation. I understand that.
Sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
The court has.
All right, court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be 16th, April 16th, 2026, 10 a.m. before Judge Washington.
Your Honor, may I briefly address bond?
Down.
He is out and he is doing really well out, Your Honor. Since he's been out, as you know, he has successfully completed his inpatient treatment. Currently, the court has him on GPS tether, which the court tends to do when we put them in treatment. My client has had no subsequent violation. He currently has stable housing. He has family members. My client is just asking that the tether come off, Your Honor.
Any response from the people?
No, Your Honor.
What city is he residing in?
I'm in Taylor.
You're residing in Taylor.
Yes, sir.
If I take it off, are you going to come back?
Yes, sir. Yes, sir.
He will, Your Honor. If the court recalls, he came back. He
How
was
was she
here.
answer that?
I just
What
want
are-
to assure you,
What are
Your Honor,
you driving or what?
I'm just so proud of him and the things that have happened since you've let him out. That's all, Your Honor. I'm just proud of him.
Me too. That didn't answer the question. Is she driving?
No, his
Okay, I just I didn't know. No.
Frankie drive.
Yeah.
Yeah, his sister is, Your Honor.
Yeah. I do have a driver's license, so I took.
I don't know, but with your because I'm just
Yes.
Bond will continue. The defendant, however, may be released from the GPS tower.
thank you so much, Your Honor.
Thank you.
Yep.
Court does call the case of People versus Arissa Rodriguez.
Okay, well, I'll speak to the people.
And public defender from Ms. Rodriguez, who is here by Zoom, I believe, Judge.
She's here.
Hi. Can you
Hello,
hear me?
state your. Yes, we can hear you.
Okay. Arcia Rodriguez, how's it going, Judge Simpson?
It's going well. Thank you for asking.
Your Honor, we're asking for a brief adjournment to discuss this matter further with the people and with Rodriguez for the reasons stated in the green sheet.
Got it. Probable cause conference will be adjourned April 2nd, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you.
Okay, thank you. Thank you so much.
You're welcome, Ms. Rodriguez.
This moment hits deep. The victim representative speaks, shifting everything from numbers to real human impact. The court now sees emotional trauma, not just unpaid money. Legally, this strengthens the urgency for restitution. But here's the question. Should emotional harm influence sentencing more than financial circumstances? This is where justice gets complicated.